If you have been hoping for positive updates regarding your green card or visa process, today brings the news you have been anticipating. Because currently in April 2026, developments are occurring within the U.S. immigration framework that have not taken place for years. Priority dates are advancing, filing opportunities are expanding, and thousands of immigrants who remain trapped in extended backlogs are now receiving a genuine opportunity to proceed toward lawful permanent residence. So remain with us because over the coming minutes I will explain all the essential details about the recent shifts, what they signify for your case, and precisely which steps you need to take immediately. Welcome back to Immigration Zone, the channel where we deliver the most critical, most current immigration information so you are never left out. Let us begin. Let us begin at the start. Each and every month, the U.S. Department of State publishes what is known as the Visa Bulletin. The Visa Bulletin is a monthly document that indicates when green card applicants may proceed with their cases according to their priority date. It lists cutoff dates for family-based and employment-based categories, assisting applicants in understanding when they can submit or obtain approval. Because there are yearly caps on green cards, not all applicants can advance simultaneously. This monthly document helps resolve one important question for millions of immigrants worldwide. Is it your turn now? Consider it in this manner. The U.S. government maintains a restricted number of green cards it can issue each year. There is a queue. Your position in that queue is established by your priority date, which essentially is the date your petition was initially submitted. Your priority date is typically the date when your family member or employer correctly submitted the immigrant visa petition for you with USCIS. If a labor certification is necessary, the priority date is the date the labor certification request was approved for review by the Department of Labor. Now, here is where the April 2026 Visa Bulletin turns remarkably promising. For years, individuals in specific employment-based categories have been waiting and waiting, observing their priority dates progress by only a few weeks each time, or sometimes remain unchanged or even regress. That difficult period of waiting is what renders this April document so noteworthy. For the first time in years, priority dates in certain employment-based second preference and employment-based third preference categories are now shown as current. And when we say current, that represents the most favorable information you can obtain. Current means there is no application queue, no delay period. If your category is current, you qualify immediately to secure your immigrant visa overseas or to change your status to lawful permanent residence within the United States. That term current is something many immigrants in the EB2 and EB3 queues had not observed beside their category for quite a while, and today it appears. Now let us discuss precisely what advanced and what it signifies for various groups of applicants. On the family-based side, the largest change occurred in the F2A category. For those who are unfamiliar, F2A includes spouses and minor children of lawful permanent residents, referring to individuals who are wedded to a green card holder or are the young child of a green card holder. The F2A category returned to current for all countries. That is substantial news. It means if you are a spouse or an unmarried child under 21 of a green card holder, there is currently no queue for you. You can proceed without delay. This represents a major development for families who have experienced separation or remained in uncertainty, waiting to join together in the United States. For the wider family-based categories, USCIS has verified that for all family-sponsored preference categories in April 2026, applicants must utilize the dates for filing chart in the Visa Bulletin. This matters because employing the dates for filing chart allows you to present your application even prior to your final approval being assured, provided a visa number is projected to become accessible before long. This serves as a useful resource because it enables you to secure your position in the queue and initiate the procedure without awaiting the ultimate final action date. On the employment-based side, the information is equally promising. EB1 and EB2 stayed mostly unchanged, but EB2 India progressed modestly, which constitutes a notable improvement considering how long Indian nationals in that category have been waiting. EB3 displayed the most notable forward progress. For India, the EB3 category moved forward in a meaningful way. For most other countries, EB3 returned to current, meaning no queue whatsoever. EB3 includes skilled workers, professionals, and other workers, which represents one of the most frequent employment-based green card routes for individuals worldwide. The reality that it is current for most countries holds exceptional importance. Now, you might be wondering to yourself, why is all of this occurring? Why are dates advancing so notably all of a sudden? This is where the situation becomes quite noteworthy. Immigration attorneys and analysts have identified a particular circumstance that is generating a special chance in the framework at present. An immigrant visa pause has impacted a notable number of countries, meaning nationals from those countries have been prevented from proceeding with consular processing. When a substantial group of applicants cannot proceed, it generates an excess of available immigrant visa numbers because USCIS and the Department of State must forecast supply and demand ahead when determining which chart applicants may employ and how much to move priority dates. This ongoing pause in processing for many countries has indicated that the total number of green cards available stays under control. That is why USCIS has kept supporting the more advantageous dates for filing chart and why dates have advanced so notably. In simpler terms, imagine it like seats on an airplane. If a large group of passengers cannot board, the seats they would have occupied become open for other passengers. Other people who have been waiting on standby suddenly receive a seat. That is basically what is taking place in the green card framework right now. The backlog for certain applicants has temporarily reduced, and that is generating a real practical opening of opportunity for everyone else. However, here is what you absolutely must recognize. This opening could end. The Department of State itself has released a notice that forward progress in 1 month does not ensure ongoing advancement in upcoming months. As further immigrant visa requests resume or as administration policies shift, retrogression is possible. Retrogression means dates move backward. It has taken place before and it can occur again. This is not a cause to worry, but it is a very important cause to proceed promptly and firmly while the opening remains available. So, what should you actually do immediately if you are an immigrant awaiting your green card? The initial action you need to take is examine your priority date. Retrieve your original petition documents, locate the date it was submitted, and compare it against the April 2026 Visa Bulletin charts. You want to review the final action dates chart and the dates for filing chart. If your priority date is before the cutoff date listed in your category and country, you may qualify to submit right now. For April 2026, USCIS has verified that employment-based applicants may utilize the dates for filing chart. This is a notable verification because it means even if your final approval is not yet assured, you can still present your Form I-485, your application to register permanent residence or adjust status, as long as a visa number is projected to be accessible before long. Why does submitting early matter so greatly? Because once you submit Form I-485, you can at the same time request an employment authorization document and advance parole. An employment authorization document means you can lawfully work for any employer in the United States while your green card remains pending, even if your existing work visa has limitations. Advance parole means you can travel internationally and return to the United States without abandoning your green card application. These two advantages alone are transformative for many applicants who have been trapped waiting. Submitting early also secures your position in the adjudication queue. With priority dates advancing as rapidly as they are right now, securing your spot could create a notable difference in how quickly your timeline to a green card progresses. Do not delay. The earlier you submit, the earlier the process begins operating to your benefit. Now let us discuss a particular approach that some immigrants are applying right now to benefit from this bulletin. It is known as category porting, and it applies for people who are in the EB3 category but may meet requirements for EB2. Many people initially submitted in EB3 because EB2 had extended wait periods at that time, but right now EB2 in some situations is advancing faster than EB3. If that matches your circumstances, you may be able to transfer your priority date from EB3 to EB2. What this signifies in reality is that you retain your original earlier priority date from when you first submitted in EB3, but you direct it toward the EB2 category if EB2 is now advancing faster. This is not as straightforward as simply changing an option. It demands thorough assessment of your qualifications, your job description, and your labor certification. But for the suitable candidate, it can substantially speed up your green card timeline. Consult with a qualified immigration attorney if you believe this might relate to you. The Visa Bulletin updates every month, and what is beneficial today might change next month, so timing matters tremendously. There is also significant news for religious workers. A bill signed into law in February 2026 prolonged the employment fourth preference certain religious workers category, known as the SR category, through September 30th, 2026. This means religious workers who are sponsored by qualifying organizations can keep progressing through the green card procedure without disruption. If you are a religious worker or your employer is a religious organization sponsoring you, this prolongation is directly applicable to you, and it is positive news. Let us also briefly cover the diversity visa situation, because this influences many people from countries with traditionally low immigration rates to the United States. The DV 2026 Diversity Visa Program has a yearly cap of approximately 52,000 visas after accounting for certain legislative deductions. Diversity visa numbers are being provided in April for qualified DV 2026 applicants across all eligible regions. If you entered the diversity visa lottery and were chosen, now is the moment to confirm your application is progressing. Diversity visa numbers do not carry over. If you do not utilize your number by the end of the fiscal year in September 2026, it is lost permanently. Check your status, collect your documents, and take action now. One more item that is worth noting for anyone who is presently in the United States on a non-immigrant work visa like an H-1B. The Department of Labor has also been reviewing wage standards for H-1B, H-1B1, E3, and PERM workers, specifically considering whether to increase the minimum wage level for those roles. This is still in the comment and review stage, but it is something employers and sponsored workers should be monitoring carefully. Higher wage levels could influence whether certain petitions are approved, and they could affect smaller employers who may find it difficult to satisfy increased standards. Stay updated and ensure your employer is familiar with these changes. So, to recap everything we discussed today, the April 2026 Visa Bulletin has delivered truly promising developments for immigrants across multiple categories. The F2A family-based category returned to current, meaning no queue for spouses and minor children of green card holders. The EB2 and EB3 employment-based categories achieved notable forward progress, with EB3 reaching current for most countries for the first time in years. USCIS verified that both family-based and employment-based applicants may utilize the more advantageous dates for filing chart in April. Religious workers obtained an extension through September 2026, and diversity visa applicants in all eligible regions can keep progressing with their DV 2026 applications. The reason all of this is occurring is a combination of a visa surplus created by processing pauses affecting nationals from certain countries, combined with USCIS and the State Department working to ensure that all congressionally authorized green cards are actually issued to eligible applicants each fiscal year. The system has capacity right now, and that capacity is being extended to those who qualify and proceed promptly. But remember, this could shift. Retrogression is always possible. Immigration attorneys across the country are encouraging applicants who are eligible right now to submit as soon as possible, secure their position, and benefit from the employment authorization and travel advantages that accompany a pending green card application. Check your priority date today, collect your documents, consult with an immigration attorney if you have any questions about your individual circumstances, and most importantly, do not overlook this opportunity. Moments like this in the immigration framework are uncommon, and the people who proceed rapidly are the ones who gain the most. And that is everything for today's video. If this information assisted you or someone you know who is on an immigration path, please share this video right now. There are thousands of people out there who need to receive this news and do not even realize it yet. Your share could transform someone's life. If you are new here, welcome to Immigration Zone. This is the channel where we explain the newest immigration news, visa updates, green card modifications, and everything in between in clear language that anyone can follow. We do this every week so that you are always knowledgeable, always ready, and never surprised by modifications in the immigration framework. Hit that subscribe button right now and turn on the bell notifications so you never miss an update. Because in immigration, being even a few weeks behind on the newest information can mean missing a filing window that does not return. We are here to make sure that never happens to you. Thank you so much for watching. We will see you in the next one. Do not forget to subscribe to Immigration Zone. Your green card journey starts with staying informed, and we are here every step of the